let's go on the record if you wanted to address some sort of issue, Mr. Zakarzeki.
Thank you, Judge.
Let's go on the record. Appearances, please.
Yeah, Mike Zakarzeki appearing on behalf of the people.
Mariah Silverstein appearing on behalf of Ms. Toman.
All right. Ms. Toman, state your name.
My name is Kelly Jo Toman.
All right. Mr. Zakarzeki.
Yes, Your Honor. We would like to, the people would oppose the inclusion of defendant's prospective expert witness, Dr. Angela Andrews, for two reasons. One, under 6201A3, an expert witness we're required to get a curriculum vitae, a report by the expert, or a written description of the substance of the proposed testimony, the expert's opinion, and the underlying basis of that opinion. We have not received any of those things. All we have is essentially a resume of this expert with her kind of honors and hobbies and stuff. And then the second reason that we oppose it is under Harbison and Thorpe, both were Allegan County cases, which 504 Mitch 230 2019. An expert witness cannot opine on whether or not a crime occurred or not, because to do so would invade the providence of the jury and is in plain error. Thus, in this case, while the defense expert can testify as to the defendant's medical conditions and physical limitations that would make it difficult for her to assault the victim, she cannot state that the defendant could not have physically assaulted the victim due to her physical limitations because she was not there and does not know whether an assault occurred or not. It would be in direct violation of the court's holding in Harbison and Thorpe. So it essentially, in addition, it presents a relevance issue.
Well, Ms. Silverstein.
Thank you, Your Honor.
I mean, obviously, let me ask you, have you provided him with a synopsis of the proposed testimony?
I have, Your Honor, and I've attached a CV. It doesn't explicitly say CV or resume, but the substance, it has education, medical training, employment history. It's several pages long. I had filed that back on September 6th, and the basis that in the summary I provided to the people was that Dr. Andrews has been Ms. Toman's primary care physician for several years. Testimony is anticipated to consist of an explanation of Ms. Toman's diagnoses and Ms. Toman's physical limitations. This isn't a case where there is a report, and so Dr. Andrews will testify to facts and based on her knowledge and expertise as a primary care physician and expert in internal medicine. She treated Ms. Toman shortly after this incident happened. She had treated Ms. Toman before the incident happened. She can testify to what she observed, and given her expertise as a medical doctor, she can go a step further to explain the medical bases of some of her findings.
Well, but to what relevance is that? I mean, she can obviously testify as to what her diagnosis has been, that's fine. She can but she certainly, I mean, to go to the point of Mr. Zakarzeki, she's not going to be able to say whether or not she committed a particular offense. I mean, I presume you are not going to be even attempting to elicit that sort of testimony, I presume.
That's correct, Your Honor. And as Thorpe has stated, I'm not offering her as vouching. What I'm offering her for is what I anticipate to be impeachment purposes or credibility issues as it relates to the complaining witness, where Dr. Andrews can testify to Ms. Toman's physical capabilities and can shed light on the credibility of the complaining witness. And credibility is always relevant.
Mr. Zakarzeki.
Yes, Judge. Touching on the relevance issue, the victim the defendant made an admission to law enforcement that she did in fact throw the cooler. That's the underlying fact of this case. So we're not sure what this expert's testimony, what it would actually be relevant to. But the second issue is we did not receive any report under 6201A3. We have a 7-page document that we received on September 6th, which is entitled Defendant's Prospective Witness List. It's 7 pages long. I don't see anything in there that resembles a report or any kind of medical diagnosis.
Did you provide a report, Ms. Silverstein?
No, but under the court rules, I don't have to provide a report. It's curriculum vitae of any expert party may call at trial, and either a report by the expert or a written description of the substance of the proposed testimony of the expert. The experts.
Mr. Zakarzeki, did you get a written summary of their proposed testimony?
No, I have 7 pages and I see nothing that is a summary of the testimony whatsoever.
That's what I just read off on my witness list.
Well, wait a minute. No. Well, so if you have it on the witness list, I'd have it too.
Yes.
All right. So I see a curriculum vitae. All right.
What we're getting at is that if the doctor had met with the defendant ahead of time, we would need that report. So that we can
Wait a minute,
understand.
are you saying the sum and substance of the testimony is what you described in paragraph 3 here? That she's going to be testifying to her diagnosis and physical limitations, and that's it?
Yes, and her physical observations.
With that. What do you mean? What does that mean?
As her treating physician, because she had appointments close in time to when this incident happened.
How is that relevant?
Because there were physical injuries left on Ms. Toman.
If I may, Judge, the defendant admitted to the assault. So we're not sure how it's relevant. Probative value of this expert testimony would be, other than I'm her doctor, I don't think she committed this crime.
All right, so you got this on September 6th. And why am I hearing about your objection to this on Friday before trial, when you haven't done a motion to strike?
I can't really answer that. This is, I mean, it's a pretrial issue. We're trying to address this before we get to trial.
Well, but the way we address things before we get to trial in this circumstance would be a motion, right? And now we don't have time for a motion. And you're asking me to make judgments, and you're asking me to correlate to what you identified to be precedent from an Allegan County court, but I don't have that stuff here to look at. I don't have an ability really to make a determination on this. If here's what I'm going to do. You got a witness list that you did not object to that was presented on September 6th. I will definitely be very much watching the testimony. It's going to be very limited testimony. It's going to be very brief testimony. It's going to be very specific as to her diagnosis. Did you have a copy of all of her medical records, I presume?
No, Your Honor. We don't have anything except for this.
How is Mr. Zakarzeki supposed to be able to prepare for this witness then, Ms. Silverstein?
My understanding is what she testifies to will be facts and evidence.
How is Mr. Zakarzeki supposed to prepare for her testimony, Ms. Silverstein?
I'm not certain, Your Honor. I provided the witness list and contact information for her to the people on September 6th.
Did you provide the medical records upon which she was going to be basing her testimony?
No, I am not, Your Honor.
So how is he supposed to prepare for that?
I'm not certain.
Well, I think you are certain. He's not able, is he?
I'm not. I don't know what you want me to say, Your Honor. I don't.
Well,
know.
What I want you to say is that you haven't provided him with a basis to prepare for the witnesses that you're asking to present.
I followed the court rule.
Did you request the medical records, Mr. Zakarzeki?
I did not. I mentioned it when we had talked earlier.
Well, never mind then. I'm going to back away from that. If you're not asking for it, then I guess I can't really expect the defendant just to say here. Although technically probably should, if you're indicating that's what she's going to be testifying on.
I mean, we're definitely say. We're definitely asking for it today, Your Honor. If the court would deem an adjournment appropriate so that we can address this issue with, more time, we would ask that as well. It is our position that we are requesting those documents, we are requesting those reports, and that this expert witness is a clear violation of 6201, as well as the two cases I cited, which were, they're Allegan cases, but they made it to the Michigan Supreme Court. So we would like to lodge our objection to this expert witness on the record.
And for what it's
Why?
worth, I've mentioned this expert at previous pre-trials. I filed my formal witness list on September 6th, but the people have had notice that I have been anticipating calling my client's treating physician.
Well, here we are, right on the cusp of trial. I mean, but the one way you get an automatic adjournment, obviously, if you wanted to address this, is to nolly it, and I certainly wouldn't require it to be on a with prejudice. So that would be, you'd have all the time in the world to be able to get all this stuff and prepare for that. But that's why we're here for. This is not something that should be coming up on the cusp of trial. We should have this dealt with by motion practice ahead of time. I should be able to review briefs. I should be able to understand what it is you're talking about. Would presume he should have the medical records to review at the very least. It's my only case for trial. It's not properly before me today. You haven't noticed a motion on it. I just find this very frustrating, and so I'm going to let you guys deal with it. I'm not going to make a ruling. Obviously, there may be some things I do at trial in regard to what I consider to be relevant. I may, not allow testimony if I don't consider it to be directly relevant. I certainly won't allow testimony if it's going to be something whether or not the witness is going to say she was not. She could not have done this. That's not going to be testimony I will allow, because that is definitely vouching. So, I mean, you can make an observation as to what a diagnosis was, and people can go from there, I suppose. Or the people, if they wish to develop these arguments and address this matter by way of a formal motion hearing, I'm fine with that. That's just going to be a requirement, though, that you're going to need to dismiss the case and refile it.
Yes, Judge, we are going to dismiss this case and refile it. We think that there's enough of an issue that it's worth a motion.
All right. I would urge you, once you do refile this, file your motion so that we hear it prior to trial.
Yes, Your Honor.
All right. You're going to send me the nollie?
Yes, Your Honor.
All right.
Ms. Homan, I'll give you a call later today.
Okay.